Good morning. We're going to get started here right away. Welcome to everyone to our fall edition of the Deborah Smith and Frank HR and Employment Seminar. We are pleased to welcome everyone here who's decided to come and join us, and welcome to everyone who's joining us online as well. We're coming to you live from Boardroom 6 at Deborah Smith and Frank this morning, so that's a first for us. We're proud to announce that I think we have our largest attendance ever, believe it or not. Online is heavily outweighing the physical presence today, but in any event, we're hopeful that you'll find our topics interesting for you, and as you know, our goal is to provide useful information to employers and give some guidance in terms of how the case law has developed in the employment law field, and really discuss topics that are of interest to you guys. So if anyone has any comments or suggestions and wants topics, please feel free to let us know, and we would be happy to cover those. We're going to follow the same format as usual, so for those of you who have been with us before, you'll know how this goes. We're going to try and get you in and out quickly. We'll avoid the song and dance of introductions and just go one after the other, and get everyone in and out. We would ask that if you have questions, you please hold them till the end, and all of our lawyers will be happy to discuss particular issues with anyone that has particular questions. But in the interest of pushing forward quickly, we'd like to hold those questions until the end. I would remind you that this seminar is approved for HRPA credits for continuing legal education, so keep that in mind, and if you would like to get credit for that, please make sure to note that on our sign-in sheet here, and or send an email to the admin group, and they would make sure that that's covered off for you. So without further ado, we'll push on with the agenda for this morning. Dealing with proposed changes to Ontario's labor and employment law, Mr. Chris Statham.
Thank you, Larry. Good morning, everyone. Let's talk about some law. So, talking about changes to the law in particular. Changes coming about as a result of the Fair Workplaces, Better Jobs Act, which is being pushed through by Kathleen Wynne's Liberal government presently. And in particular, because this is an employment law seminar, I'm going to be focusing on changes to the Employment Standards Act. I'm sure you're all aware, because this is mostly HR professionals and some lawyers, that the Employment Standards Act sets out minimum standards applicable to all employees in Ontario. Minimums in terms of what employers are required to provide by way of vacation and through the regulations, wages, etc. The changes are, as you'd anticipate, favorable to employees in that they aim to increase some of those minimum standards. In particular, the changes aim to address this concept which was identified as precarious work. So what brought about the proposed amendments was a review of the legislation undertaken earlier in the year. I think the report came out in May of 2017, and it's 400 and some odd pages, very detailed and careful analysis of our jurisdiction as compared to certain other jurisdictions. And it was the first ever independent review of the Employment Standards Act. It's also a review of the Labor Relations Act. We're focusing on the ESA. And so they identified this concept of precarious work, where you've got employees in Ontario who have a difficult time earning a decent income, difficult working conditions. You have problems with unequal pay for equal work, an abundance of temporary workers going in and out of various jobs, things like that, makes it hard for certain people to make ends meet. And the statistic, and this is sort of I think not a particularly precise concept, or maybe it's not, there's no possible way of getting an exact nail down as to what the minimum is supposed to be, but according to the criteria that were applied in the report, you've got 30% of Ontarians in 2014 that found themselves in this position. So the recommendations are supposed to create better workplaces. The quote that I've pulled out of the report, which I think sort of speaks to the ideals of the report, is up on the slide, and it says, "A society where decent labor standards are observed and respected in the vast majority of workplaces, and where rights to meaningful collective bargaining are acknowledged and not undermined, would ideally result in an economy based on sound and ethical foundation and workplaces that are productive and fair. Overall, our society would be a better place, and we would all benefit." Oh, who could disagree with that? It sounds fantastic. Everyone's aware that the minimum wage is going up. It's going up to $15 an hour by January 2019. Lots of news about that, of course. So let's talk about the changes. There's some very interesting changes. You might say, you know, it's early in the morning, talking about changes to legislation. It sounds awfully dry. You know, give me something to wake me up. In this case, the changes are so many and so significant that I put to you that this is actually pretty interesting stuff. So the first change, and we've talked previously at our seminars about the distinction between employees and independent contractors. So, you know, who's an employee, who's an independent contractor? Person that comes to this office every day, does various stuff, files stuff, types stuff, whatever, gets a paycheck every 2 weeks. Well, that person's pretty clearly an employee. You know, I need my roof replaced at home, and I call a roofing company, and they come and replace my roof. Well, that person's not likely going to be my employee. They're typically going to be an independent contractor. So there are all these clear cases, and then all kinds of shades of gray in between. Under the proposed changes, there will be an automatic presumption that a worker is an employee and not an independent contractor. Where there's a dispute about where the worker is an employee or an independent contractor, the employer is going to have the obligation to prove that the person is an independent contractor if that is, in fact, their position. Now, you might say, well, why does this matter? Well, it matters for a lot of reasons. For tax purposes, it matters whether someone's an employee or an independent contractor. But you might also have a situation where an employer wants to categorize someone as an independent contractor in order to deny them the minimum entitlements of the ESA, put them in that precarious work position. So you're not entitled to vacation. I don't have to withhold source deductions, all that kind of stuff. The other interesting thing about this change is that the distinction already exists in law in Ontario between employees and independent contractors, but the way it works now is if an employee takes the position that they're an independent contractor, then they go to the Ministry of Labor and they say, hey, I'm not getting my vacation pay. The Ministry of Labor will hold a hearing, they drag you all into a boardroom and they do their investigation, and at some point someone makes the decision, well, no, this person is in fact an employee, they're not an independent contractor. So there are all the things that come with that. Oh, you didn't pay them their vacation, you didn't pay them this, that, whatever. So slap on the wrist, get on with your life. Well, I think part of the idea is, I'm not sure that that really makes sense, right? So what the Act will do is it's actually going to impose penalties if the employer does that. And from a common sense perspective, that kind of, it seems like it should be obvious, right? I mean, if I get caught stealing, I'm walking out of the store with something, I shouldn't just go, oh, you got me, I'll pay for it, right? There's supposed to be some deterrent, something to stop me from doing that. And so I think the idea with the proposed amendment here is to say, okay, if you're actually going to mistreat a worker by denying them protections of the ESA, we're not just going to say, oh, you know, now we've decided they're an employee and you've got to treat them as an employee. There will actually be a penalty for the employer, and that can include prosecution, public disclosure, fines, etc. So just a minor note here, the definition of employee doesn't change in the Act. It's just that the presumption exists. There's a minor change to it, which is on the slides. I'm not going to go through it. The second relatively significant change is that the employee, assuming that this Act becomes law, will be able to request changes to work schedules or work locations. So how it will work is they put the request to the employer in writing. The employer will either have to say, okay, I agree, and this is when you're going to start at the new location or you start your new hours, and then, or if they disagree, they have an obligation to provide reasons. So that is going to be set out specifically in the Act. Addressing again the concept of precarious work. So the amendments are going to bring temporary help agencies or temp agencies within the scope of the ESA. There are a bunch of definitions that are going to be added of temporary help agency and assignment employee, and there will also be a notice requirement. So this is sort of similar to what you see set out in the termination provisions of the ESA. So if someone has worked for more than 3 weeks per the termination provisions, 3 months as per the termination provisions, there's an obligation to provide them with a week notice of termination, and there's a sliding scale that goes all the way up to 8 years, I believe it is. In this case, if someone has been posted to a 3-month assignment through a temp agency and they get cut off short, they're entitled to a week's notice or pay in lieu thereof. You've probably heard about the 3-hour rule. It's not currently in the Act. It's set out in the regulations under the Act. So the idea is if I get called into work and I'm scheduled to work 3 hours or more, and then after an hour, my boss says, sorry, Chris, I got nothing for you to do, go home, I'm still entitled to get paid for 3 hours. So that's still going to be there, but it's going to be moved from the regulations into the Act, and it's going to be expanded a little bit. The terms, as set out in the slide, are going to be changed a little bit. This isn't currently what's in the regulation. The language here is what's going to be proposed in the Act. And there's an exception built into it if the reason that I can't work for that amount of time is due to some kind of act of God, like lightning or a power failure or something like that, the obligation isn't triggered. Now, here's an interesting twist on it. If I have a shift and it's canceled within 48 hours before I was supposed to start work, then I'm still entitled to my 3 hours. And you should also note with respect to collective agreements, if there's a collective agreement in place, they can override that provision. Similarly, minimum payments for being on call. If the employee is on call and is not called into work or works less than 3 hours, you're still entitled to your 3 hours pay. Again, can be overridden by a collective agreement. The right to refuse work is going to be specifically set out in the Employment Standards Act. So if I get a last-minute request to show up to my job, last minute meaning less than 96 hours before the proposed shift, I have a right to say, no, I'm sorry, I'm not available, but I do have an obligation to let my employer know as soon as I can. And again, if there's a collective agreement that says something else, the collective agreement prevails. This is a minor sort of one, but it's an administrative clarification in terms of overtime pay. So this contemplates a situation where I work in 2 different jobs for the same employer. So, I manage the night shift at a warehouse, and I also drive a forklift. If I have to work overtime, my overtime pay is not 1.5 times the lower amount, it's 1.5 times whatever I'm doing. So if I work overtime managing the night shift and that's my higher rate of pay, my employer can't pay me 1.5 times what I'd be paid for driving a forklift. The calculation of public holiday pay is going to be clarified. Right now it's a pretty complicated formula. If some of you in HR have dealt with it, you have to add a bunch of stuff up and divide something. And now how it's set out on the screen, this isn't all of it. It's still complicated enough that I didn't put it all in the slide because it wouldn't fit, but it's going to be simplified significantly. So people will understand how it works. There's going to be a change to how vacation pay works. So presently, as you know, everyone's entitled to 2 weeks paid vacation per year, 4%. There's going to be an addition to this. So if the employee has worked for more than 5 years, then it gets up to 3 weeks pay at 6%. The idea being that this will bring Ontario more into line with what other employees in this country are entitled to receive. Again, going back to that concept of precarious work. So the Act, the proposed amendments to the Act will provide for equal pay for equal work, and they will employ a mechanism whereby if someone thinks they're not receiving equal pay for equal work, they can put in a request to their employer, request a review. The employer then has an obligation to adjust or provide a written response with reasons for the disagreement. Similarly, in terms of equal pay for equal work, it's not just limited as between sexes. Part-time employees are entitled to be paid the same as full-time employees. Again, there's a mechanism put in place whereby someone can put in a complaint or request a response from their employer, and there will be an obligation to either adjust the pay or provide detailed reasons. Again, temporary help agencies. Temp workers will be entitled to be paid the same as regular workers. The mechanism is in place, and they can request a written response from their employer or a change to the pay rate if no written response is provided. This has been coming down the pipes, I think, for quite some time, but there's going to be some changes to how paid leaves of absences are dealt with. An employee will be entitled to 2 paid days and 8 unpaid days each year for things like illnesses and emergencies. The paid days have to be taken before the unpaid days, and the employer is entitled to request evidence of the need to take the time off. There's been some discussion, you may have seen in the news, about what is an employer is entitled to by way of reasonable evidence, whether it's reasonable to be requiring doctor's notes, particularly in circumstances where certain people who are not covered by OHIP actually have to pay for doctor's notes, so it's arguably not unfair when we're trying to eliminate precarious work. The other problem is there is some question as to the practical utility of requesting doctor's notes, because in many cases, if I stay home because I'm sick and then my boss says, oh, I need a doctor's note, I go to the doctor the next day when I'm feeling better, and the doctor's really just relying on me saying that, well, I was sick, will you please write me a note? So if the doctor's prepared to do that, I mean, what's the difference between that and just going into work and saying, I'm sorry, I'm sick? It is perhaps a practice in some cases to be discouraged. However, you can't have no mechanism there, so the word reasonable is used in terms of reasonable evidence. Entitlements to medical care leave is going to be expanded. Personal emergency leaves are being expanded. So there's this concept of crime-related child death or disappearance leave, which entitles an employee to a significant amount of time off. It's being changed to child death leave and crime-related child disappearance leave. And it's to be expanded to 104 weeks. Interesting, you'll note if the parent employee is charged with a crime in relation to their child's death, then they may not be entitled to that leave. So there's well, yeah. So it's interesting though to note that, because it just says charged with a crime. It's not convicted of a crime. So if you're convicted of a crime in relation to the child's death, then you've got bigger problems. You don't care whether it's 104 weeks or some other amount. But this applies particularly to cases where you're charged. And crime-related child disappearance week, also 104 weeks. And there are various criteria. I'm not going to go through all of it in detail. That would make what I would submit to you as an interesting presentation into one that's more dry, but you can go through them if you need to. A significant change. So in terms of a sort of greater policing of all this, if we're going to have greater accountability for employers, we want the employees to be able to make the complaint to the Ministry of Labor without having an obligation to notify the employer. And also greater publication rights. So these things can be published on the internet so that if the employer is doing that bad thing, again, the idea is to wave a big stick, not just correct the action, as in the case with the employer and independent contractor, but actually, so in addition to the fines, this can be published on the internet that the employer has contravened the Employment Standards Act. The definition of tips is to be expanded. Again, you're dealing with people in a position of precarious work. You don't want the employer to be able to share in tips that are meant for the employee. I haven't included the definition, but it's, if you want it, I can send it to you, and it is online. And the policing itself, the ambition is to hire up to 175 more employment standards officers, which is a huge number. You might wonder where we're going to get all the money for that. And you do notice that it says up to 175. So whether and how that's going to work in practice, but with all these new rules, something's got to be done, or else we're going to be in the same position we are now, and effectively it will have the impact of not adopting the recommendations that were set out in the report. So stay tuned. This thing passed the second reading relatively recently and has been referred to the Standing Committee on Finance and Economic Affairs. So there are still changes being made and revisions, but I think it's anticipated that it will likely pass relatively shortly. So that's everything I have to say about changes to the Employment Standards Act. I'm going to invite my, my colleague Larry Cowan back up here. Larry's going to be speaking to you about entitlements to bonus during the employee reasonable notice period. Thank you.
Thank you, Chris. So, employee entitlements to bonus payments. This is one of the most emotional and highly litigated issues in employment law. So we're going to cover three basic things for you today. The entitlement to bonuses, and really that is a distinction between whether they are discretionary or they are integral to the compensation of the employee. Number two, there's been a recent decision of the Court of Appeal called Paquette, which we'll go through, and it deals with the actively employed language that's often in bonus policies. And then number three, some calculation issues related to bonuses. So number one, bonuses that are an integral part of the compensation of the employee are generally considered to be payable as part of any termination notice payment. And integral compensation is usually fairly commonsensical in the sense that if an employee has a relatively small base salary and has a very significant bonus component, so that a significant part of their compensation overall is by way of bonus, it will often be viewed by the court as being integral to their compensation. Similarly, if the compensation is by way of bonus, but the bonus is often the same and it's repeatedly the same every year, the courts will determine that it's really an integral part. If, however, it's determined to be discretionary, the court will say that those bonuses are not payable in the event of a termination. So you really have to look at each case, you have to look at the language, and you have to look at the history of the bonus payments to try to figure out whether or not it's integral or whether or not it really truly is discretionary. There's a number of cases where, although the language says discretionary, if the history is not, the court will take a different view. So a leading recent case from 2006, which is affirmed by the Divisional Court last year, is Fraser versus Comparators. Comparators is a metal supply company, not to be confused with a medical company that delivers blue pills and things like that. Mr. Fraser's job was to basically acquire other companies, and then once they were acquired, to manage the acquisition and make sure that it went smoothly. So he had a fairly significant and senior role. He was paid a significant salary, $205,000 a year, and he was permitted to participate in the bonus plan. There was no actual plan or no actual written policy. There was no formula, there was no floor, there was no ceiling. Really, it was just the owner and his daughter, and they kind of just made up numbers and handed them out every year. And the case shows there was a history of some people getting 100% of their salary as a bonus, or in some cases getting nothing. So in that scenario, Mr. Fraser sought to get his bonus. He, in his first year, got a bonus of $50,000, and that was only actually a part year of working. In his second year, 75. His third year, he got a $175,000 bonus. In his fourth year, which was the year in which he was terminated, he got none. So obviously, he was upset by that, and obviously the employer was quite keen on not paying it. In the end, the court held that it was, in fact, a discretionary bonus. They said that the history was such that Mr. Fraser had signed up for an arrangement where he might get one or he might not, and the employer was extremely clear that in that scenario, it was an entirely discretionary bonus, and there was no obligation on the employer to pay. So, and as I said, the divisional court confirmed that just last year. So that's a bit of an example. There's a million of those examples, so we're not going to be able to go through all of them, so we're going to move on to topic number 2. Topic number 2 is actively employed. Now, employers will often try to limit bonus payments by the language of their policy agreements, and particularly in the year of termination, it's often a major concern for employers. So as employment law lawyers, that's the first place that we have to look and see what is the language and what does it say. Many of the bonus plans, and there's a million cases, maybe not a million, but a lot of cases about bonus plans which tend to have language that require an employee to be actively employed at the time of the bonus in order to be eligible to receive it. So obviously in scenarios where there's a termination and there's a lump sum payment, and as opposed to working notice given, the employee is often not actively employed on the relevant bonus date, and that tends to give rise to a bunch of case law. So in 2013, there was a case called Bernier and Nygaard, and in that case, employees, in order to be eligible for a bonus, they had to be employed on November 30th. Mr. Bernier was terminated on December of 2012, and his 2012 bonus was paid, but his 2013 bonus was not. Ultimately, the court held that he was entitled to a 12-month reasonable notice period, and so doing the math, December plus 12 months would have gotten him to the November 30th bonus date. And so in that scenario, the court held that, in fact, the 2013 bonus was due and payable to Mr. Bernier as well, even though he hadn't worked there for the entire year. The court said that effectively a notice period is by definition intended to be a working notice period, and if the employer chooses to do something else, that's their prerogative. However, the employee is considered to be employed during that period of time, and any compensation that they would have earned during that working notice period, they're entitled to receive, including a bonus. Now, that tends to fly in the face of the word actively employed, but that was the state of the law in 2013. Then in 2015, Paquette and Tarago Networks came along, and at the first instance at trial, Mr. Justice Perel, who was my prof at law school, and I think he knew some stuff, but he maybe got this one wrong. Anyway, he held that in that particular case, bonuses were payable to employees who were actively employed by Tarago on the date of the bonus payout if they met the personal and corporate objectives. So in that case, bonuses were payable in February of every year, and Mr. Paquette was terminated in November 25th, 2014. So Mr. Justice Perel held that a 17-month notice period was appropriate, but in that case, he held that there was no bonus payable. He relied quite specifically on the language of the contract, which required active employees. And he held that because the employee was not active here, he was simply in his working notice period that was in fact paid out by a lump sum instead, that he was not entitled to the bonus. The employer appealed, and the Ontario Court of Appeal last year in 2016 reversed Mr. Justice Perel and held no, that in fact the bonus payment is payable. So that sort of caused some uncertainty, but seems to be the latest state of the law. So from the Court of Appeal, there's sort of the three keys that we want to take. Where an employer elects not to give working notice and pay a lump sum instead, all of the benefits that an employee would have received if they had worked during the notice period must be continued, including bonus payments. Bonus agreements that require an employee to be actively employed is not enough and is not going to sufficiently displace the employee's entitlements to that bonus. So arguably, this pushes the law either back to where we were in Bernier or maybe even a little bit beyond that, because the court seems to suggest quite expressly that the language that is used in the bonus agreement or in the bonus policy kind of doesn't matter. Even if the word actively is in there, the court effectively said we're going to sort of disregard that. So this has the effect, obviously, of making bonus policy agreements difficult to enforce, and it certainly makes limiting bonuses by contract more difficult. Some of the commentators have said that really employees have an implied right to a bonus, and so if an employer elects to give a lump sum payment instead of a working notice obligation, that in that scenario, really the employer's already breached the contract and has said, you know what, I'm not going to give you actual working notice. And so the court is therefore saying if you're in a breach, you can't rely on the agreement that you're trying to enforce. I'm not sure that's the appropriate language, and we're going to have to see how this develops over time. But at this point in time, it's very difficult, it seems, to limit bonus entitlements even by virtue of contract. Now, having said that, I want to take you to one example where the court went the other way, and this was now pre-Paquette, so take that as a caveat. But in this case, Keeld versus National Money Mart Company of Canada, and I know Mr. Keeld, I went to law school with him. Nice guy, but he signed a bad contract, I think. So in that case, the court found that the bonus payment in that case was an integral part of his compensation. So right off the bat, it wasn't discretionary. It was very much part of what he thought he should earn and was entitled to earn. Except the contract had this provision in it. Any bonus is entirely at the discretion of the company, does not accrue, and is only earned and payable on the date it is provided to you. For example, if your employment is terminated with or without cause on the day before the day on which a bonus is payable, you hereby waive any claim to that bonus or any portion thereof. You also hereby waive any claim to constructive dismissal based on the fact that a bonus wasn't paid. So you really can't get more clear than that. And in that particular case, the court said, yeah, that's what it says. Mr. Keeld, you went to law school. We're going to uphold that provision. Now, again, the caveat is that this case was pre-Paquette, and is so we'll see how the court deals with Keeld and Paquette now that both of those decisions are out there together. And also, the other caveat is that in this particular case, Mr. Keeld was only entitled to an 8-week notice period. So we're not in that same scenario where there's a big, long notice period that might otherwise wrap you around to another bonus date. So we'll see. But at least that's an example of how employers can limit it if they're trying to do that and hopefully withstand that. Now, whether an employee will sign an agreement like that is another issue, I guess. And fairly obvious point here, but obviously any bonus agreement or policy has to be made known to the employee. Otherwise, the limitation provisions and the language that limits that is not going to be held to be valid. You know, many of these bonus policies are fairly thick and quite filled with a lot of legal language and are often attached to schedules or after the fact kind of things. So it's important to make sure that these things are brought to the employee's attention. It's important to make sure that they read them, sign off on them, etc. So just be wary of that issue. Calculating bonuses, number 3 topic for the day. Paquette is also a useful decision in that it upheld the approach used in Bernier to calculate bonus entitlements, which is really an averaging based on the history. In Bernier and also in Paquette, they used a 3-year average, and whether it's 3 or 2 or 4, I guess that I think remains open to be debated. But in Paquette, Mr. Paquette got bonuses in a relatively narrow range: 2011, 27,000; 2012, 31,000, 2013, 27,000. And ultimately, the court said, we're just going to average those, and we're going to award $29,000 as the number. So, you know, in that kind of a scenario, it's obviously fairly easy and fairly obvious. If we were back in the Mr. Fraser scenario, where it's 50,000, 175, that obviously makes it a lot more difficult, and it becomes a bit more of a difficult analysis. But what's important is that in some of these cases, the employer didn't present alternative calculations. So the employee presented a calculation to the court. The employer didn't present one. And so the court said, well, I guess we're going to go with yours. So, you know, obviously it's important to make some kind of a determination about this and make some kind of an analysis and try to figure out what a reasonable number would be. A second approach that's used is one called an average of comparators. This is from a Bain and UBS case in 2016, where essentially the court looked at bonuses that were received by other employees at the employer in the same year. Sure, although it is fraught, I think, with a bit of difficulty in the sense that there are a lot of other issues at stake. Some of, you know, other employees may have different salary levels. Other employees may have very different performance levels. So just because employee X got a bonus of a certain amount doesn't necessarily mean, I think, that employee Y is entitled to that amount as well. But it is a methodology that has been approved by and used by the court in the past. So there you go. Now, that would be the end, but I do have a little bit of extra time, it looks like, so I have a bonus topic for you. So in 2016, when Paquette was released, the Court of Appeal also released a second decision at the same time called Lynn and Ontario Teachers Pension Plan. And that case is again, fairly obvious, but I think it's a point worth noting in that case, the employer sought to amend its bonus plan to make it harder to claim bonuses in the year of termination. Unfortunately, they did that for existing employees as well, and they did that without providing any additional consideration. And of course, certain employees refused to sign. The employer said, well, okay, and they just kind of went on with life and didn't sort of do anything about it. Ultimately, Mr. Lynn was terminated, and the employer sought to rely on the amended version of the policy. Mr. Lynn said, nope, I didn't sign that, and the employer argued that Mr. Lynn had acquiesced by virtue of staying employed and not doing anything about it for many years after the fact. Some of you are rolling your eyes, which is good, because obviously that's not a technique that's likely to work at the end of the day. And fortunately, or unfortunately, I guess depending on how you look at it, but the court upheld that provision, upheld that position, and said that no, the amended version's not binding. And in any event, you should look at the Paquette case, because working notice, he would have gotten it, and it wraps around and all the other issues. So the court tied those two cases together when they released them, but the Lynn case is really for this second proposition. So. Thank you. That's my time. Up next is Justin, who's going to speak to you about the legalization of marijuana in Canada and give you some advice about that.
Good morning, everybody. As Valeria said, I'm Justin Lynch. I'm here to speak to you today about the legalization of marijuana in Canada, and more specifically, how that will impact your workplace policies. So we'll be talking about the current and future legal status of marijuana, random drug testing, duty to accommodate, and essentially employer best practices on how to deal with this coming legislation. Currently, as we all know, marijuana is illegal. Under the Controlled Drugs and Substances Act, it is absolutely prohibited to possess, traffic, share marijuana. The only exception to that is if someone requires it medically. And there's a separate act, the Access to Cannabis for Medical Purposes Regulation, which allows people to essentially order marijuana, grow their own marijuana, so long as they need it to soothe their medical issues. It's treated much like other prescription pills or drugs that they may receive. Recreational marijuana, however, continues to be illegal until July 1st, 2018, which is the proposed date that the Liberal government has brought forward as the date marijuana will be legalized. It's interesting, a lot of people have different takes on whether or not marijuana should be legal or not. I know that in my former life I was a federal crime prosecutor, so I spent a lot of time prosecuting many individuals for both possession and trafficking of marijuana, along with other narcotics. A lot of your tax dollars went into this prosecution, whether it was paying crime prosecutors, court times, police officers who spent countless hours arresting people for what many view as a relatively minor offense. Some people feel otherwise. They may oppose what's going on, feel that it should remain illegal. But what is clear is that workplaces are going to have to adapt to the change. So on July 1st, 2018, recreational use is legal. The proposed legislation would allow adults 18 and over. Well, in Ontario, it's actually going to be 19 because each province can decide their own legal age. But it will allow someone to possess up to 30 grams of marijuana or other forms of cannabis. They could also share that with friends, co-workers, potentially. They could buy dried cannabis or cannabis oil from essentially what will become some sort of LCBO type store. The Ontario government is still working on that, but they propose to have up to 100 stores ready to go by July 1st. Although the last I heard, if they can get 30 up and running by that date, I think they'll be happy with that. The legislation will also allow individuals to grow up to 4 full-size plants in their personal residence or yard. So you might find your neighbors if you peek over their fence. If you see some unknown plants, that's what it might be. There would, however, be legislation prohibiting the sale to minors, much like alcohol and cigarettes, and also legislation against people driving while impaired. So how do we deal with it at work? Well, currently, anything that's non-medically prescribed is prohibited, it's illegal, still can't do it. Once legalized, marijuana should essentially be treated the same way as alcohol. So I ask, how many employers have alcohol policies, have drug and substance abuse policies? Is it a zero tolerance policy? And if so, how do your companies deal with those liquid lunches where everyone goes out and shares a bottle of wine or has a beer or two? Is it truly zero tolerance, or is it always kind of a wink, wink? We're going out to celebrate a birthday. It's okay. And if that's the case, how will you react in those same circumstances where instead of splitting a bottle of wine, your employees are going out and sharing a joint? It seems bizarre, like, how can that happen? But with the coming legislation, it's a real issue that's going to have to be confronted. So employers will have the right to prohibit the use of marijuana during working hours. You can also, of course, prohibit attendance at work while impaired. But impairment and measuring impairment when it comes to marijuana is not easy. There really is no accurate test for marijuana, and there's no government-set guidelines yet on what constitutes impairment. They're working on it. It's not here yet. Police officers are going to have to deal with essentially the same issue. Again, going back to my time as a federal prosecutor, you pulled somebody over, you think they were impaired, you couldn't just give them a breathalyzer. That didn't exist. They're working on it, but it's not there yet. Systems for controlling potency will need to be based on consistent quality and known dosage. So it's hard to measure how much somebody has taken, how much somebody has ingested, how much somebody has smoked, because there is no proper scale to truly do it. And that's for a variety of reasons. Marijuana builds up in the body. It's not like alcohol, which leaves the bloodstream relatively quickly. The level of marijuana's key ingredient, THC, does not accurately correspond to impairment. It affects everybody differently. And the physical effects of the drug for alcohol or other illegal substances can be quite easily discoverable. Marijuana is different. Yes, there may be a smell involved, but some courts have said smell is not enough to impose remedial action. And while it's not in the legislation yet, some marijuana can be ingested edibly. You can put it in cookies. You can put it in brownies. Certainly, if someone's having a snack at their desk, there's going to be no way of knowing whether your employee is consuming it or not. So how do we confront this? Well, some places, some jurisdictions, especially in the United States, can institute employee drug testing. The guidebook in Canada essentially says no, you can't do that unless there are specific circumstances that you're dealing with. So by default, you should absolutely assume that Canada does not permit pre-employment or during employment drug testing for drug or alcohol use or impairment. That's because privacy interests will, in almost all cases, trump the employer's right to know if their employees are on drugs. There was a Supreme Court decision, CEP Local and Irving Pulp and Paper, and that essentially held that random drug testing will not be upheld unless the employer can show actual evidence of a substantial safety problem. And the law kind of breaks it down into two different branches. There is safety-sensitive environments, and that often deals with warehouses where people are driving heavy equipment, motor vehicles, trucks, and then there's the non-safety sensitive environments like most offices. So random testing in those safety sensitive environments, well, the threshold, again, even in these circumstances, is very high. The employer must establish that it faced enhanced safety risks, which is essentially evidence of substantial substance abuse problem in the workplace. Kind of hard to understand where they're coming from here because it's almost like the chicken and the egg. If you can only drug test once you are aware that there's a problem, it makes it difficult to implement policy to prevent it in the first place. But yet, that's where we are. Non-random testing in safety-sensitive environments is a little bit different. The employers can require employees to undergo testing. This is specific employees when there's reasonable cause to believe the employee is under the influence of drugs or alcohol while on duty, or when the employee was involved in a workplace accident or a near-miss accident. If there is reason to believe that that accident or near-miss was caused by impairment, then you may be allowed to implement drug testing. Also to note that in very limited positions, but there are some, you can, in fact, institute drug testing prior to employment commencing, but after the offer was made of employment. But note, even if the potential employee comes back and tests positive for drugs, it doesn't matter what that drug is, you can't necessarily just terminate them on the spot. Because you've offered them that employment already, it would give rise to a duty to accommodate that employee. In those non-safety sensitive environments, like most offices, in almost no cases will random testing be justifiable. It really can only be implemented for employees who agree to it, and that's if let's say they go off work on short-term disability or long-term disability to deal with substance abuse issues. As a condition of coming back to work in some limited cases, you may be able to have them drug tested in those cases. The non-random testing, again, not likely to be justifiable. There would really need to be a significant workplace incident before you can show that testing is required. If you can prove that the policy of drug testing is rationally connected to the work and it is imposed in a good faith effort to achieve the purpose to ensure safety and compliance in the workplace, then it may be. However, again, in most cases, privacy concerns will always outweigh it. So what is the employer's duty to accommodate? Legislation, Human Rights Tribunal have shown that drug dependency and drug abuse is a disease, and it must be accommodated much like all other diseases. So, to that end, there's a clear duty to accommodate individuals with prescription for medical marijuana. It's got to be treated just like you would any other form of disability. But before you open it up to anyone who says they've got a medical dependency on marijuana, and I know this because I would say 99% of those people that I prosecuted, whether they had a medical prescription or not, that's the first thing they said. They need it, right? They could have been an 18-year-old teen, 35-year-old parent. It didn't matter. It's when they showed up to court to discuss their case, they said, I'm sick and I need it. And the first question we would always say is, okay, show us the prescription, show us the evidence. So that's what employers need as well. Medical proof of the prescription, or at least at bare minimum, a sufficient medical indication that the employee actually needs it and needs it during working hours. So you can also require sufficient detail regarding the frequency, volume, and method of ingestion relating to the prescribed medical use. How about the recreational users? You have to accommodate them. Short answer is no, you don't. It's not a disability. If someone likes to use it on the weekend, the legislation will now allow them to do that, but they don't have the right to partake at work. Employers can continue to maintain the right to prohibit impairment on the job, particularly in safety-sensitive positions. And again, that was just the cautions, again, just what I note. What do employers need to accommodate? How far does that accommodation need to go? As I was saying, a prescription does not entitle an employee to be impaired at work. It does not entitle an employee to compromise his safety or the safety of others. A prescription or an accommodation does not entitle an employee to smoke in the workplace if it's in violation of Ontario's non-smoking guidelines. A prescription for medical marijuana does not entitle an employee to unexcused absences or late arrivals. However, it will give rise to other accommodations in terms of work schedules, perhaps additional breaks, and accommodations in that sense. Okay, so before I wrap up, just to talk briefly about employers' best practices, what you can do to be proactive in dealing with the proposed legislation. Include a duty to disclose any use of marijuana in the workplace. You can make that part of your employment contract. You should modify policies to specifically deal with marijuana dependency. You can require a qualified proof of prescription and necessary medical ingestion note so that you are aware of exactly what your employees need while they're at work. You should also establish a framework for testing impairment if possible, including triggering circumstances, testing methods, or mandatory medical examination. You should note that you do have the obligation to accommodate those who require medical marijuana, and you can train employees on the policy and train your supervisor on how to best recognize impairment. It's not going to be easy, but with the proper training, it is something that can become possible. And you should make the consequences of any breach or non-compliance with your marijuana policy clear to all of your employees. Finally, I just want to talk briefly about a recent case that came out of the Supreme Court of Canada. It was a rather interesting one. It was Stewart and Elk Valley Coal Corporation. Mr. Stewart was essentially a truck driver or in an underground mine. He would be carrying loads back and forth. He was involved in a workplace accident, and they tested him after the workplace accident. He tested positive for cocaine. And he was terminated with cause, and he fought that at the Alberta Human Rights Commission. He went there and argued that his drug dependency was a disability, and therefore his termination was discriminatory. Luckily, his company, Elk Valley Coal Corporation, had, as a term of their employment contract and their drug policy at work, that all drug dependency must be disclosed. The Alberta Human Rights Commission upheld the termination and said that it was not discriminatory because he simply didn't disclose his drug dependency, and the company would have had no way of supporting or knowing what his issues were. Mr. Stewart didn't like that answer, so he took it to the Alberta Divisional Court, then the Appeal Court in Alberta. Eventually, it worked its way up to the Supreme Court of Canada. And it was a split decision, but the majority did uphold the termination. They said that he was not terminated Mr. Stewart was not terminated because of his drug dependency. He was terminated because he did not comply with the company policy of disclosing his drug dependency. I found that decision rather interesting. It was a split decision. The minority felt otherwise, and there was one particular dissent which believed that the termination was discriminatory, but at the end of the day, the majority of the justices of the Supreme Court upheld the termination, and that decision is just one reason why it is vital that each and every drug policy that all companies have explicitly states out what employees are responsible for, what their duties are, and how far the accommodations can go. So I thank you for that. Thank you for listening. If you have any further questions, or for those who may have lost audio at their place of work, feel free to contact me with any questions. And then I'm going to turn this over to Alexander Tratnik, who will be discussing social media with you. Thank you.
Thank you, Justin. Today, my topic today is termination for cause in the age of social media. I will briefly describe to you today termination for cause, which many of you are probably very familiar with already. And then I will go through this in the context of social media and off-duty conduct, as well as some recent examples from the case law. So employers typically have two means of ending the employment relationship. One, termination with notice. So you either give working notice or pay in lieu thereof. And the next one is termination for cause, where the employer terminates the relationship without notice and the employee essentially walks away with nothing. The general test for just cause is you need to show that the employee breached a fundamental component of the employment relationship, and that such breach warrants a termination. Courts and arbitrators have determined that you need to take a contextual approach with this, and that each case is determined on its facts. So here, more serious repeat conduct for employee lends itself to a better finding of just cause, and the key here is proportionality. Any discipline for the employer or employee must match the conduct. Here's a little handy chart. So one-off mistakes, minor lapses in judgment, so low chance of being terminated for cause and not being upheld. Where someone is charged with a crime or has major repeated lapses in judgment, will have a for cause dismissal is more likely. So there's another thing called cumulative cause, and this is where there are multiple incidents in an employer's behavior where employers must demonstrate the accumulated series of events together constitute a fundamental breach of the employment relationship, and were accompanied by warnings for which the employee will know that his or her job was in jeopardy. The reason for these warnings is to give the employee a chance to respond to the allegations and to correct any deficient behavior. So off-duty conduct and just cause. Courts and arbitrators have found that an employee's off-duty conduct can lead to workplace consequences, including termination for cause. And off-duty conduct means employee conduct that occurs outside of the workplace hours or the workplace environment. In the context of social media, this includes Facebook posts, Instagram posts, Twitter posts, and other forms of social media. Where the misconduct happens outside of the workplace, the onus on the employer is modified slightly. Here, the employer must show a real and material connection to the workplace, and that a reasonable person would conclude that the employment relationship has been damaged to the point that further employment is impossible or untenable in the circumstances. So things that an employer must show include whether the harm or whether the misconduct harmed the employer's reputation or product, whether it rendered the employee unable to perform his or her duties, whether the misconduct led to the refusal or inability of other employees to work with him or her, and whether the employee has been found guilty of a criminal offense, a breach of the Human Rights Code, or other employee policies, for example, anti-harassment policy. So it's not necessary for the employers to show that all of these conditions exist, but rather you want to show that the degree of the behavior or the misconduct warrants termination without notice. And in determining this, courts will consider a variety of factors, including the length of service, so how long has that employee worked with the employer, level of position held. A manager is going to be held to a higher level of standard than someone in a lower position. And another consideration is whether there is a policy made by the employer that limits social media or off-duty comment or off-duty conduct. Sorry. So in sum, what does this leave us with? To dismiss for cause as a result of off-duty conduct, the employer must show, one, that it's material related to the workplace. There has to be some kind of connection. People need to know that this employee worked at, X company. Two, that there is a fundamental breach of the employment relationship. And three, given the severity of the misconduct off-duty, that termination for cause is warranted. So to bring this all together, let's discuss some cases so you can kind of put it all in context. The first one I'm going to talk to you about is City of Toronto, so Toronto Fire Services, and Local 388, so it's the union that represents the firefighters. In this case, there was a male Toronto firefighter who had been working with the city for about 2.5 years. And he tweeted some pretty racist and sexist comments on his Twitter account, which I know was private, and can't remember exactly how many followers he had, but not very many. Somehow, though, his tweets were picked up and published by the National Post. And I'm going to read a couple of them just so you get an example of how bad they were. One was, reject a woman and she will never let it go. One of the many defects of their kind, also weak arms. Another tweet was, and excuse my language, I never let a woman kick my ass. If she tried something, I would be like, hey, get your bitch ass back in the kitchen and make me some pie. A third one, which I will also read, but again, excuse my language, the way to a woman's heart is through anal. So he's posting comments like this on his Twitter account, and another significant point is that his picture included him in a Toronto Fire Services uniform. The employee thought that his tweets were private, but again, they were picked up by the National Post. The employer terminated his employment for cause and stated that his tweets violated the employer's human rights and social media policies and specifically harmed the reputation of the Toronto Fire Service, who at around that time was specifically had a recruitment campaign trying to get more female firefighters on the service, as well as more minorities to reflect the diverse city of Toronto. And the employee's position was that what he did was not criminal and that some sort of lesser penalty was warranted in the circumstances. So the decision was here, the arbitration found that dismissal for cause was warranted. The arbitrator held that the employee's conduct harmed the reputation of Toronto Fire Services and impaired his ability to fulfill the complete range of responsibilities that a firefighter has. And I'm going to read you her quote here because I think it was well worded. She stated that the job involves more than attending a fire or attending as a first responder when someone calls for 911 for a medical emergency. It involves more than performing life-saving interventions that he has learned and practiced. The other part of the job, the part that I'm not convinced he can perform to satisfaction, is a part that requires him to conduct himself in a way that brings honor to the uniform. I have to wonder if a deaf person, a woman in labor, a homeless person, a member of a visible minority group, apprised of his comments, would welcome this man into their home in a time of need. So this case demonstrates that certain types of employees, for example, firefighters, nurses, police officers, might be even held to a higher standard than a regular employee whose work is less intimate and does not involve serving the public or being in a position of trust. The next case I'm going to talk to you about is Kim and the International Triathlon Union. This is a BC case. The facts here is that there's a senior manager posts negative comments about her boss and coworkers to a personal Facebook and Twitter accounts. The employer had informal discussions with the employee about the content of these posts. The employer, noteworthy, did not have a social media policy. The breach here, according to the employer, was that they felt that there was a reputational harm and there was a follow-up in the workplace after criticizing these supervisors. The employer felt that the employee's actions destroyed the trust between the parties and made it impossible to go forward. The employer's position was that the employee's position that there was no clear expectations that the conduct was unacceptable. It wasn't offensive or demeaning to the person in question. It was just a personal issue the employee had with somebody else. In this decision, they found that the dismissal for cause was not warranted and the plaintiff was awarded damages. Here, the court focused on the employer's failure to expressly warn the employee about her conduct. So maybe in a case for a cumulative cause where there were several instances of this happening and the employee gave, or the employer gave several written warnings indicating that she might be terminated if her conduct is not improved. Maybe in that case, maybe a dismissal would be warranted, but here there was no formal warning, and so the decision was that it wasn't proper to terminate her without cause. The third one I'm going to talk to you today about is McKinnon and Helpline, Inc. The facts here is a 16-year management employee speaks to a reporter about her employer and makes disparaging comments made via her personal email account and private Facebook messages. This mostly occurred outside of work hours. The employee had been told by the board that the communications were unacceptable. The breach here, the employer states that the employee harmed the company's reputation and there was a breach of trust, and that her conduct harmed the workplace relations between the employee and the supervisors. Here again, the court held that the dismissal for cause was not warranted. The conduct in question happened over the course of 3 weeks after a 16-year record of unblemished work performance. I think that was important for the court. Another important consideration, that there was no opportunity given to the employee to respond to the allegations made against her. She was terminated almost immediately. And another consideration was that the employer didn't conduct an adequate investigation into the incidents prior to termination. They kind of jumped to conclusion and fired her and didn't give her any chance to respond. The last one I'm going to talk to you today about is Tenaris Algoma and Local 9548. Here, the facts are there was a male crane operator that complained about a female coworker on Facebook. His posts were vicious and humiliating and could be considered by some as threatening to her. as one example of his Facebook post, he suggested that his female coworker be sexually assaulted. He didn't use her name, but didn't identify her through a unique physical characteristic, which anyone working with them would have known that he was talking about this person. His Facebook post, and the court took, or the arbitrator took note of this, is that they were visible to people outside of his friends. So I don't know if they were public or maybe friends of friends, if you know how that works on Facebook. And another consideration by the arbitrator was that his posts weren't deleted immediately. They were left on for about 10 hours. And one coworker did respond to the comments. The employer said this was a breach of the employment relationship and that it undermined the reputation of the company. It made his comments on Facebook made it impossible for him to work with female staff in the future. Female staff would probably not want to work with someone like this. His comments also breached the anti-harassment policies of the employer, and the decision notes that even though the anti-harassment policies didn't specifically mention social media like Facebook, it didn't really matter. They still had harassment policies that were breached. And so the arbitrator held that the dismissal was warranted, especially in light of the nature of the comments were serious enough to warrant termination with cause. So that termination was upheld. So what can you take away from all this? Number one is to perhaps create a social media policy that is communicated and understood by employees. You're going to want to set out what is acceptable and what is not acceptable and let your employees know so they have a better understanding of what's going to go forward. And if something does happen, you can refer to it and go from there. The other thing to consider is to use progressive discipline for employees. You know, only the most serious offenses should warrant immediate termination for cause. So in terms of, minor, indiscretions on Facebook, and you kind of want to nip that in the butt, you might want to have some sort of progressive discipline. If you have employees that are doing something outside of work hours that you are not in love with, but it's not so serious to, terminate this person immediately, you might want to set out some warnings and take it step by step. And third, coming from these decisions, is that you should consider a thorough disciplinary procedure that investigates, relies on the facts, and gives the employee a chance to respond to the allegations before making a decision whether or not to terminate for cause. So that's what I have to say on that. Up next is Marty Rabinovich. He's my colleague, and he's going to talk to you about termination clauses. Thank you.
Well, thank you, Alex, for that presentation, and good morning, everyone. My name is Marty Rabinovich, and today I will be speaking to you about termination clauses. Again, I believe that was the topic that I spoke about at the last one of our employment seminars. You have the pleasure of hearing from me yet again. So before we get into this, let's just set out what we mean by termination clauses. So if we have an employment contract that is silent about an employee's entitlement upon termination without cause, the default is that that employee is going to be entitled to a common law reasonable notice period. And a termination clause is a clause that rebuts that legal presumption of common law and replaces it with another entitlement that is agreed to by the parties. It will almost certainly be less than what the common law entitlement will be, or else what's the point? But it must be equal to or greater than what is set out in employment standards legislation. So for provincial employers, we're talking about the Employment Standards Act, and for federally regulated employers, we're dealing with the Canada Labour Code. Now, many termination clauses have been found to be unenforceable by the courts. Some people have estimated that to be somewhere around 30%. It's hard to know exactly what that number is, but assuming that it's even anywhere close to 30%, that's a lot. So if you are an employer who does rely on termination clauses in your contracts or would like to do so, it is very important to get legal advice about that. There are a number of things which could be included in termination clauses. So sometimes we see termination clauses which contain formulas for calculating the notice period based on the employee's years of service. So something like the employee will be entitled to 3 weeks per completed year of service or something like that. There are also termination clauses which I've seen which contain a fixed notice period. So by that we mean if the employee is terminated without cause, the employee will be entitled to, say, 8 months of notice, regardless of what the circumstances are. I would caution employers about that because depending on what number you pick, that might not be enforceable, so careful. We also see termination clauses which will specifically set out the employee's entitlement to benefits and severance pay. We have termination clauses which set out the employee's entitlement to variable compensation throughout the notice period. So we're talking here about bonuses, stock options, commissions, and so on. And finally, we also have termination clauses with language which may specifically limit the employee's entitlement to their minimum entitlements under employment standards legislation. And that's really the focus of the remainder of this presentation. So I want to get into now some common mistakes and drafting errors that we see that could invalidate a termination clause. So the first one is if we have a termination clause being inserted into an employment contract by an employer without giving that employee fresh consideration. So by that we just mean something new, a new benefit for the employee that they don't already have. So if an employer tries to do that, the new termination clause will not be enforceable. If we have a termination clause that the court finds to be ambiguous, the court will interpret the ambiguity against the drafting party, which is almost certainly the employer, which will almost certainly mean that if we're dealing with a termination clause that is ambiguous, it will not be enforceable. Another problem that we see is if we have a termination clause which provides less notice to the employee than the minimum standards would give that employee, which you can't do. So that's also unenforceable. Another problem, and this is one that we will get into in more detail, is if we have a termination clause which does not specifically mention the employee's entitlement to benefit continuation throughout the notice period, or if there's even no reference to the employee's entitlements under employment standards legislation, which has been held to include benefits. In the case of certain federally regulated employees, those employees can make an unjust dismissal claim under the Canada Labour Code, and it has been held that the adjudicators of those claims are not actually required to follow the language set out in the termination clause. So that might be another way for the employee to get around it. And finally, if we have a termination clause that may cause an ESA problem in the future, that's going to be unenforceable. There's conflicting case law about that as well. So again, if you're an employer and you really want to do something like that, just be careful. Okay, so the remainder of my presentation, I'm really going to focus on number 4 here, and that's the references to benefits in the termination clause. Okay, quickly before we get into that, another reminder, if the termination clause in an employment contract is found to be unenforceable, it's as though it's not there, okay, and we go back to the common law. So under the Employment Standards Act, the most that the employee would be entitled to for notice and severance is 34 weeks. So that's 8 weeks of termination pay plus a maximum of 26 weeks of severance pay, so the total being 34 weeks. At common law, the unofficial cap on reasonable notice is 24 months. So there is a huge difference, of course, between 34 weeks and 24 months. So it is important, okay? So I'm just going to jump right ahead to the number 4 problem here, which the case is focused on. So this is the problem again about a lack of mention of statutory benefits. And as we'll see, over time, the courts have been quite divided about whether a termination clause is unenforceable because it does not mention the statutory requirement to continue the employee's benefits throughout the notice period. So we start off with the first approach, which is what we call the employee-friendly Sifton line of cases, and that comes from a case called Stevens and Sifton Properties Limited, in which the court found that the termination clause that did not provide for benefit continuation during the notice period, they found that clause to be unenforceable, despite the fact that the clause was otherwise compliant with the statutory minimums. And the court's reasoning in this case was that if an employer wants to contract out of the common law and say that we're only dealing with the minimum standards here, we can't just pick and choose which standards we're going to put in the language. We have to include all of them. And because the Employment Standards Act clearly identifies benefits as an entitlement for the employee, if we don't say anything about benefits, then that's going to be seen as an attempt to contract out of the Employment Standards Act, which we cannot do, which results in the clause being unenforceable. Okay, and then, so there's many cases which follow this reasoning in Sifton, and another significant one was actually decided in February of 2017 by the Ontario Court of Appeal, which is the highest court in Ontario, and this one is called Wood and Fred Deeley Imports. So in this case, there was a termination clause. The contract said nothing about benefits or severance pay and contained a clause which stated that the employee was not obliged to make any payments that were not set out in that paragraph. So we had a paragraph which was meant to be all-inclusive but did not comply. So consistent with the reasoning in the Sifton line, the termination clause was found to be unenforceable. And another quick note that the court addressed in this case is that it's not enough for the employer to comply with the benefits portion of the ESA after the fact and then rely on that in order to cure the poor drafting. Okay, the court specifically said that we can't do that. So even if we have a termination clause, which has everything in it except for the benefits, and the employer at time of termination says, oops, I made a mistake, but don't worry, it was always our intention all along to give you those benefits, and here they are, that is still not good enough, and that clause is still going to be unenforceable. And then we get into the second approach, which we call the employer-friendly Rodin and Udant line of cases. So the first case is called the Rodin and Toronto Humane Society, also decided by the Court of Appeal, but this one's a little bit older. It was decided back in 2005. And in this case, the court upheld a termination clause that did not explicitly provide for benefit continuation, but provided an employee with the minimum amount of notice or payment in lieu thereof as required by the applicable employment standards legislation. Now, in this case, the court interpreted the clause to mean that payment and salary were two separate things, and therefore did not include benefit entitlements, and so concluded that there actually was no intention of the parties to contract out of the Employment Standards Act. Okay, however, more recent cases do take issue with this reasoning, so if this case were decided today, probably the court would find it ambiguous, and you would end up with an unenforceable termination clause. Okay, so that was Rodin. Then we get into to the Houdin decision. So this is a 2016 Court of Appeal case called the Houdin and Centre Francophone de Toronto. So in this case, the termination clause did not explicitly provide for benefit continuation, and also included one of these all-inclusive type language clauses. So clearly the language did not comply with the Employment Standards Act, but the court takes an interesting approach here. This is why we call it employer-friendly. The court basically looks at the context in which the contract was made, and actually looks at the employer's conduct after the termination, and then uses that to come to a decision about what the intention of the parties was at the time of drafting, and basically says, well, what's most important here is the intention of the parties. The intention of the parties was not to contract out of the Employment Standards Act. It was rather to comply with it. So even though, you know, the language may not be perfect, we're going to decide that this clause is enforceable. Okay? So we have two separate approaches here. Where does that lead us? And then we get another decision from the Court of Appeal. This one is very, very recent, October 16th of 2017, just about a week and a half ago. And it's another case about termination clauses. So this time we have a termination clause which entitles the employee to the minimum entitlements under the Employment Standards Act. And, you know, as we start reading the clause, the drafting is actually looking pretty good, right? But in this case, the court finds that the offending part of the termination clause reads as follows. It says, any payments owing to you shall be based on your base salary. Now, at first glance, probably that doesn't really seem so bad either. The problem, though, was that the employee was also entitled to commissions under this agreement. Okay? Commissions are wages, and if you don't pay an employee their wages, well, now you have an ESA problem. You're not complying with the Employment Standards Act, right? So ultimately, the court finds this termination clause unenforceable as well. So I would suggest to you that this very recent decision is more in line with the Sifton approach over the Rodin and Houdin approach. So I would suggest to you that going forward, when we're dealing with these termination clauses, really what's important is the language itself. You must comply with the Employment Standards Act in the language. The Houdin approach, where we're looking at the context of the contract, is probably not going to fly going forward. Okay? So once again, I will just remind you that if you want your termination clauses to be enforceable, we highly recommend seeking legal assistance. It's a complicated issue, and the consequences are serious. So thank you very much. That concludes my presentation, and now I will pass things back over to Larry, who will conclude. Thank you.
Thank you, Marty. Thank you to everyone. Those are our presentations for today. As I said at the outset, if you have any questions that arise from the presentations or otherwise, feel free to contact either the relevant lawyers or any of us. We'd be happy to help. The video from today will be posted up on our website, as many of the other previous ones have been. So if you are looking for something to do, you can go back and look at old presentations and old topics and spend your day doing that. We would obviously welcome any comments that you have, and if you'd like to get notices of the future upcoming dates and things like that, please feel free to sign up for our newsletter, which you can do through our website. We send out a quarterly newsletter on not only employment law, but many other topics from the various lawyers in the firm. The next date for our spring seminar will be in April. We haven't finalized the date yet, but look for those notices coming out. We will be having another one in April, and look forward to seeing you all there or online. So thank you for coming. Help yourself to the main food, and appreciate your time. Thank you.